Hey, good afternoon. Good afternoon. I think we cranked up. All right, we'll move on to the next one. I don't see Rick Williams here, so we're going to go ahead with Representative Gullett to present a bill.
Thank you, Mr. Chairman. Good morning, or I guess good afternoon, members. This bill, everyone says a short bill. This is one of the shortest changes that you'll ever see, but it is pretty impactful. This is related to the sex offender registry, and it changes on line 17 of the legislation, an or to an and. So today in Georgia, if you are a convicted sex offender who's been ordered by the judge to be on the sex offender registry, you have two ways of petitioning the court to be removed from that. One is you're a tier one, so we have a group called SORB who rates you. If you're a tier one, you can petition a judge to be removed from the registry, or in today's world, if it's been 10 years since you were convicted and finished your sentence, you completed your sentence. What I'm looking to do is change that or to an and. And the reason is pretty simple. I think we're an outlier in Georgia. I want to give you some different states that have sex offender registry lists and what they do. California. Today, California, they have a three-tier system with a minimum registration periods of 10 years, 20 years, and life. Registration may be terminated upon petition to Superior Court in the county at expiration of the minimum sentence. So today in California, minimum sentence, the minimum time you're on the sex offender registry is 10 years. Connecticut, a full pardon erases the conviction, but there's no other provision for early termination. Hawaii, any person can petition the court for relief after 40 years of completing their sentence. Certain tier 2 offenses may petition after 25 years, and certain tier 1 offenses may petition after 10 years. New Jersey may petition the Superior Court for relief 15 years from later of conviction release. New York, person classified as a level 2 offender not designated a sexual predator or sexually violent may petition the sentencing court for termination after 30 years. Person classified as level 2 or 3 can petition for a lower level, but still 30 years for the level 2. So you can get so if you're a predator, you can ask the court to reclassify you, but you're still held at the time. Massachusetts, 20-year registrants may petition the Sex Offender Registry Board for termination after 10 years. So getting a little more local in the Southeast, Kentucky, there's no provision for early termination of mandatory terms. Early termination available in case of a pardon or reversal of conviction. North Carolina, 30-year registrants may petition the Superior Court for termination after 10 years. Reversal, unconditional pardon for innocence relief. So basically, if you're pardoned, there's no other way. 30 years is if you get a 30-year sentence, you only have life, and 30 years, 10 years, you can petition the court. North Carolina. South Carolina has no provision for an early termination. Florida may petition the circuit court for relief 25 years after release of a less serious offense. Tennessee, registrants for nonviolent offenses may petition Tennessee for termination after 10 years if the victim was not 12 years or younger. Alabama is pretty complicated. They have a bunch of different tiers, but 10 years is what Alabama, for the most part, has. And the Fed sentence they have a life, 25-year, 15-year. You can do a 5-year reduction for tier 1 offenders after 10 clean years. Like I said, in Georgia, you could potentially be a sex offender, a tier 1 sex offender, and petition the court as soon as your sentence is done. They could terminate probation, or you can fulfill your probation and immediately get off the sex offender registry list. And these tiers, I think I have some speakers today to kind of tell you, the tiers is not necessarily what you've done, it's the percentage of chance that you're going to be a recidivist. But oftentimes these acts are still really, really horrible, really gruesome. And there's a board who looks at this to try to determine the likelihood that you are a recidivist, but to never be on that list potentially is a problem. And we have some judges in Georgia today who believe that if you qualify under one of those, you qualify to be removed from the list. So it's completely judge's discretion today. But there are judges who read that and say, you've met one of the criteria to be removed. I'm granting your removal of that. That's not, as a sex offender, you need to be on that list. We need to know who you are for a period of time. So tier ones, this would change. You must be a tier 1, and you got to be on that list for 10 years. If you're a tier 2 or a predator, you're on that list indefinitely, unless you get recategorized by the court. You can petition the court to do that. There's an option for that. But that's what this bill does. Happy to answer any questions of you guys, and I appreciate the hearing today.
Thank you, Representative Gallagher. Any questions? I see none, so we do have someone that wants to speak to the bill. We'll start with Sergeant Lenny Carr. I'm sorry. If you come in.
Good afternoon. My name is Sergeant Lenny Carr. I'm with the Paulding County Sheriff's Office. I appreciate the honor and privilege to speak with you today in support of this bill that Representative Gullett is proposing, I should say the alteration of it. I've been working crimes against children since 2007, so it's been off and on total about 14 years working mainly cruelty and child molestation cases. Hundreds of arrests, as well as convictions. And as of now, as of last year, I'm also in charge of the sex offender registry. And I can tell you firsthand, even as a level 1, and I can't attest to what the board does as far as how they classify. I know a little bit about it, but what I can tell you, however they classify it, in the state of Georgia alone, as of last week, level 1 offenders, we're talking people that have been convicted of aggravated sexual battery, 1,332 people. Aggravated child molestation, 554 people on the registry. Child molestation, 1,304 people. And that's through the GBI, Sex Offender Registry, and this was as of last week. And that's just at the state level. At the county level, I'm holding 58 level 1s. The numbers are pretty much the same as far as we've got several that were a level 1, but also were convicted of child molestation, aggravated child molestation, child pornography, which is sexual exploitation of children. Ladies and gentlemen, there are a lot of these offenders that have reoffended. Throughout my career, I have arrested several for the second time. I can give you studies that show that recidivism is a problem. There's studies that go back to 2003 where they actually track the average recidivism was around 60%. And there's several studies out there. But we see it firsthand. We see a lot of the sex offenders reoffending, different levels, but also on the level 1. And I've also had to witness in my county where several of the level 1s did get off the registry when, in my experience and everything that I have worked on, they should not have been off the registry yet, as they're still a danger to the community until deemed otherwise. Is there any questions?
Does anybody have any questions? We don't have any questions at this time. Thank you very much for coming, Sergeant Carr. We appreciate that very much. All righty. All right, Mr. Rollins.
It's on your website. Good afternoon, Chairman. Good afternoon, committee members. My name is Matthew Rollins. I am a prosecutor in Paulding County. I've been a prosecutor for about 10 years now, all of which has been in Paulding County. And I'm speaking to you today in support of Representative Gullett's bill. So a few things that I just want to make sure that everybody is clear on. 42-119 provides multiple different ways in which an individual can request to be removed from the sex offender registry. The only portion that this bill is seeking to address is Section 2, which allows for either 10 years from the completion of their sentence, or if the person has been categorized as a level 1. Well, I believe the unintended impact that you have with this is a defendant who has completed their prison sentence and now is serving their probation time can file a motion with the court and request for early termination of probation and to be removed from the sex offender registry. And pursuant to the way this law is currently written, that is allowed, and a judge can and has done that. I've opposed that in multiple hearings, and it has been granted in multiple hearings in my county. And what this would do is close that loophole, so that if you can still petition to be early termination of probation, but you're going to have to wait and be part of the sex offender registry for at least 10 years before you can make that request to be removed from the registry. There is a definite difference between probation and sex offender registry or sex offender conditions. And I think what you can get in opposition of this bill is some of those extreme examples of individuals where something as part of the sex offender registry has somehow impacted their life, ruined their life, job opportunities, and so on and so forth. What I would point out to the committee is that that same defendant can request the court to be removed from that portion of the registry. So if, let's say it's a housing requirement, we've had this before, where they are living 200 meters or 100 meters too close to a church or a playground or something like that, they can request an exemption to be allowed to live at that home and address that hardship. And the court can examine it and make a determination, and the state can be heard at that time. So those extreme examples, I believe, are being can be addressed in other means other than a wholesale let's remove from the registry. So I'd ask that I am in support of this bill because it closes an important loophole that is being exploited in our courts today.
Do we have any questions for Mr. Rollins? Do appreciate it. Don't see any questions. Thank you so much for coming.
Thank you, Mr. Chairman.
Do we have any other questions? We got one more on Zoom. Ms. Causey, if you want to go ahead.
Hello, Chairman. Thank you very much. My name is Maisie Lynn Causey. I'm General Counsel for the Georgia Association of Criminal Defense Lawyers. This is a deceptively short bill, and because the entire context of 42-119 is not included in the bill, I would like to take you back to that code section to illustrate the number of factors that someone has to meet before they can actually petition the court for removal under this particular paragraph. So if you'll see there at line 12 of your bill, an individual has to meet the requirements of paragraph 4 of subsection A. And if we go to 42-119 A4, before someone can even file a petition, they have to have completed all of their probation, parole, prison, supervised release, any kind of correctional oversight that they were sentenced to. They also have to meet the criteria that are set forth in 2 other code sections in Title 17. The factors that they have to meet within those code sections include the petitioner cannot have any prior sex offense conviction, and that's within Title 16's Chapter 6, which includes all of the sex crimes, anything you can imagine ranging from pandering to rape. They cannot have any prior conviction of one of those offenses. They can have no prior conviction related to obscenity offenses respecting children. They can have no prior conviction for any offense under federal law or another state law that would be analogs to those crimes I've just described. The petitioner cannot have used a deadly weapon or any object that could be used defensively as a weapon in the course of the underlying offense for their conviction for which they're on the registry. The petitioner cannot be in a situation where the court found any kind of similar transaction evidence when the case was resolved. The victim in the case cannot have suffered any intentional physical harm during the commission of the offense. The petitioner cannot have transported their victim during the commission of the offense. And the victim cannot have been physically restrained during the commission of the offense. So essentially what this criteria does is greatly narrows the number of people who qualify even to begin to file a petition for removal from the registry. And I think that has been overlooked here so far today, that we are not talking about every person on the registry qualifying for this particular route for removal. It is a very narrow group of people. And the narrowing actually doesn't end there, because 42-119 has a couple of more hurdles, and those are the two that the bill seeks to combine here. Right now, they are, of course, in the disjunctive. Now, because they are in the disjunctive right now, someone that is a level 1 or level 2, I would be surprised if someone that qualified as a sexually dangerous predator would meet the criteria I've already described to you today, though I cannot guarantee they would not. But by combining these two sets of criteria in this bill, you are ensuring that people who are at least a level 2 will not be able to pursue this route of removal as they could today. And I think the other thing to consider is that the language in 42-119 is very clear that this is a discretionary decision on the part of the judge. So this is not something that is a guaranteed, removal is not guaranteed for someone simply because they file a petition. And a judge is in a great position to hear all of the evidence and all of the information about the person beyond just the aggravated nature of what the crime might sound like. People are not leveled by SOAR based solely on the elements of the crime for which they are convicted. They take many factors into consideration. But I know it's tempting to want to hear those difficult charges and assign them a certain level of gravity, but SORB takes in all of the circumstances of the person's life and the underlying facts of the crime, which can vary greatly, even if we label it, for instance, sexual battery. A key distinction that I would like to bring to your attention between level 1 and level 2 classifications is the likelihood of recidivism. And that really is a pretty vague distinction. We know that I heard the deputy describe that there are bad recidivism rates. There is plenty of research also that shows that over time, recidivism drops precipitously. For instance, there was a 15-year sexual recidivism analysis done where while 14% of the offenders in the analysis were recidivists after 5 years, only 7% were recidivists after an additional 5 years. And so remember too that we're talking about a 10-year gap, as you'll see on line 15 of your bill. Not only does the person have to get through all of the criteria that I began my testimony with under paragraph A, I've lost where we are in the code, but C2A, a 10-year time period would have to have lapsed subsequent to the sentence that the person served. So we are well beyond a decade's worth of time by the time that person can petition under paragraph A. And with respect to the changes of classification, the black letter of the law with respect to changing someone's classification requires that a petition be lodged 30 days within the first leveling by SORB. It's only within those first 30 days that someone can file for and challenge their classification as level 1, level 2, or sexually dangerous predator. And even still, when there is a review of someone's request for those types of changes, it's going to the hands of a judge. We can trust our judges because the judge is not able to render their decision until after, like I said, the person has jumped through all the other criteria, in many cases waited 10 years, and is making their petition. And you'll see then when you move on to line 18, which is paragraph B, that only applies to the level 1 offenders, which is, and I don't know that it's been said, but level 1 is the very lowest level. It's not a high level. It's the very lowest level, the people that are on the registry that basically cause us the least concern with respect to fear of recidivism or fear of continued malfeasance. So the only way to access that subparagraph B right now is to have been leveled as a level 1 from the start. And I would encourage you, please, to consider leaving this code section the way that it is. It does accomplish much good by requiring a lot of conditions to be met before someone can petition. It leaves that petition decision in the hands of an elected judicial official in our courts. We understand that removal from the registry is a significant request. No one involved in the process takes it lightly. And I think knowing that the person who is petitioning has followed all of the conditions of their sentence, they have met all of the criteria laid out in Title 17, and in many cases have waited 10 more years without any trouble to lodge their petition. We ought to give them that chance. We ought to let people learn from their mistakes, be rehabilitated, come back into our society without continuing on with a lifetime burdened by their registration on the sexual offender registry. We urge you to please leave 42119 as it is today. And I would stand for any questions that your subcommittee has, sir.
Anyone have any questions?
I do, Mr. Chairman.
Go ahead.
Yes, sir.
Thank you. I'm new to this, so I need a little bit more education. And I certainly listened closely to what you and the other speakers have said. I think you're both correct in terms of there tend to be high rates of recidivism for those that commit sexual offenses, but what you stated is also correct based on my understanding and research. Is the longer time period between the incident, the less likelihood of recidivism. But I want to get into just some of the mechanics because I don't know them. So in terms of the board making these decisions, understanding that the level 1 is the lowest level, one, how long does the board usually take? Because as I read this change, if we were to do this, if there was not a level 1 risk assessment conducted, then that would need to be conducted. So I have a question of how long that would take, because that will add some additional time to the process. And who I don't even know like what the board does. So even some elementary education on that. Is it psychiatrists, psychologists, like what angle are they coming at, and how are they coming up with this determination that there is an unlikelihood of recidivism for those that are in the level 1 category? And the last thing is just, can you emphasize the distinctions between level 1 and level 2, and how do they make those determinations? I recognize there's some guesswork to this, but whatever additional information you can have would be helpful, because I just don't know the answers to these questions.
Certainly, Representative Holcomb. I wonder, because we're not in the room, if there is anyone from SORB that is in the committee hearing space. I can speak, I can tell you, I can read to you what's on their website with respect to the levels. I wouldn't want to speak for them about their processes, and I'm certain that they wouldn't want me to either, just to be candid. But could anyone in the room let us know if there is someone from SORB available?
There's not.
Okay, so then I feel like it would only be right for me just to read to you what's available publicly about the designations. So SORB describes a level 1 as an individual that is a low risk of sex offense and low recidivism risk for future sexual offenses. Level 2 means that the offender is an intermediate sex offense risk and an intermediate recidivism risk for future sexual offenses. And that includes sexual offenders who do not meet the criteria for either sexually dangerous predator or level 1. There is not much laid out publicly about the underlying criteria for those tiers.
And each individual is reviewed by the board itself, is that correct? And then they make these assessments?
I'm sorry, I didn't interrupt you. We regularly attend the SORB board meetings. They occur once a month. In fact, your colleague, Chairman Reeves, is among the, Representative Reeves is among the board members right now. he could certainly give you more insight than I could. But what we observe happen in those proceedings is that it is clear that a case review is done of each of the individuals by evaluators that are on staff at SORB. And they do include mental health professionals. And then the board reviews the case. There's a report that's provided to each board member, not publicly available, of course, but each board member then gets to review the evaluator's report. And then they pass on whether they agree with the level 1, level 2, or sexually dangerous predator designations. But the contents of those reports, I would have to direct you to SORB for more information about the details there.
All right, thank you. I'll do some more study on it. And so from what you said, there's 3 designations, is that correct? The sexual predator, level 2 and level 1. Those are the 3 that we're talking about. Okay.
That's right.
All right. Thank you. Thank you, Mr. Chairman.
Thank you. Any other questions? Do I hear a motion? Well, we didn't know it was a hearing. That's good. We thought it was a vote.
Yeah, please vote on it. I'm not trying, I think you told me it's a hearing, but if it's something else, then that's good.
It doesn't say on our agenda it's a hearing.
Awesome.
Representative Gullett, are you good?
Yes, sir.
Well, let's hear a motion. Got a motion and a second. All in favor, say aye. All opposed?
No.
One opposed? Ayes have it. It passes. Thank you very much.
Thank
I
you
do
all.
want to say thank you to you speakers, Ms. Causey and Ms. Rollins and Sergeant Carr. Thank you so much for coming down for that. Appreciate it very much. Appreciate it.